Hello everyone dan salam sejahtera to our fellow partners and speakers, distinguished guests, ladies and gentlemen, viewers, listeners and participants. Welcome to the Nanotech Talk 2021 webinar under the Nano Kebangsaan 2021. My name is Amirul Ashraf and I'll be your host for today. For your information, Nano Kebangsaan or NanoKEB 2021 is a partnership program between Nano Malaysia Berhad NMB and National Nanotechnology Centre NNC under the Ministry of Science, Technology and Innovation MOSTI. It is a virtual event that consists of activities which are virtual exhibition, forum, nanotech talk, seminar and many more. NanoKEB event focuses on the nanotechnology development in Malaysia aligned with the National Nanotechnology Policy NNP. NNP consists of 4 strategic levels that will be supported by 15 strategies and 32 initiatives with special focus on the area of energy, environment, agriculture, medicine, electronic devices. The initiative aims to bring Malaysia closer to the aspirations of the National Science, Technology and Innovation Policy to become a high-tech nation by 2030. Our event partners under Nano Kebangsaan are National Nanotechnology Centre (NNC), Nano Malaysia Berhad (NNB), Malaysia Nanotechnology Association (MNA), Sirim Berhad, University Teknologi Mara (UITM), Nano Verify Sendirian Berhad (NVSB), and University Kebangsaan Malaysia (UKM). To begin our webinar today, I would like to share a bit information about our webinar. Our session is called Nanotech Talk webinar, which is a virtual session that consists of Nano Malaysia strategic partners and speakers. Nanotech Talk is a yearly event by Nano Malaysia Berhad that focuses in 4 key strategic sectors. Number 1, electronic devices and systems. Number 2, food and agriculture. Number 3, energy and environment. And number 4, wellness, medical and healthcare. Our theme this year aligned with the national initiative in empowering the Industry Revolution 4.0 and the Internet of Nano Things IoT. This webinar aims to showcase valuable insights by featuring the nanotechnology, market trends and issues mainly for industries, companies, startups who like to venture into nanotechnology and understanding what Nano Malaysia offers. Distinguished guests, ladies and gentlemen, viewers, listeners and participants, before we start the session, allow me to give a brief introduction about our session today by Encik Muhammad Fairuz from Intellectual Property Corporation of Malaysia, MyIPO. Encik Muhammad Fairuz holds a master degree in Intellectual Property from University Kebangsaan Malaysia, UKM. He was appointed as Director, Intellectual Property Academy, IPA, Intellectual Property Corporation of Malaysia, MyIPO. In June 2021, he also used to be in the Department of Trademarks and Geographical Indications. Without further ado, I will give the floor to Encik Muhammad Fairuz from Intellectual Property Corporation of Malaysia, MyIPO, to deliver his presentation about our topic today, which is nanotechnology, overview on commercialization from IP perspective. Dipersilakan Encik Fairuz.
Assalamualaikum warahmatullahi wabarakatuh. Thank you, Mr. Chairperson. First and foremost, I would like to thank the organizer for inviting me to involve in this prestige program, NanoKEB 2021. So, and also I wish to congratulate Nano Malaysia for celebrating the 10 years anniversary. For this event, I'll be invited to give such a talk or discussion regarding a topic overview on commercialization from IP perspective. Basically, before I go further, nanotechnology is progressing under the list of the patent application in MIPO. So we hope that nanotechnology clusters can grow better and in the future can become one of the leading cluster in list of patent application in Malaysia. So as I just mentioned just now that my topic regarding to the overview on communication from IT perspective, I would like to start introduction on the IP, intellectual property. Is basically talk about the creation of mind. Means to say that the creation of mind involve the day-to-day business activities, whereby divided to two, industrial property and also the creative industry. So from this intellectual property, they give us such appreciation, acknowledgement to a kind of the intellectual creation. So it means that this intellectual property have a more powerful or more safeguarding the business and also the trading. Not only in Malaysia, is also involved the whole countries. Okay, basically the intellectual property system, one is talk about monopoly. So when you have such an intellectual property, so you're able to have such a monopoly over and above to your creation. Second is appreciate or they acknowledge the ownership of the intellectual creation. Third is we talk about the legal rights that provides to the intellectual property, the creation of mind that the inventor or the creators provide have developed certain such new product or services. And fourth, intellectual property also is regarding to the economic rights given to the creators, given to the inventor and also the owner of that intellectual property. So the others is talk about the moral rights. The moral right is under the purview of copyrights, whereby it gives us such such of appreciation to the authors. There's no time limit. It's continue given moral rights to the authors as the works is be used or be published. Okay, overall, if you can see that intellectual property gives us such recognition. That's the thing, the important thing. So such a recognition and acknowledgement for the creators that give us such of what call harmonizing the usage for the public use. So if you can see the list or at the right side is protected under the legal framework. Okay, so this legal framework also is the same as the others asset, like cars or like housing. Okay, so it's the same that the law provide such recognition for the intellectual property. Okay, on top of that, there's always we can see that there's a word of the invention and innovation. This to just to share with you some to say such a discussion about invention and innovation. When we talk about invention, we are relates to the subject matter that discover a new or invent something new or novel. So this is mentioned under the section 12 of the Patent Act that invention is regarding to problem solving in the field of technology. So means that invention, when you talk about the terminologies of invention, is a reflect to the under the patent law, whereby it is need to fulfill the requirement of newness or novelty. Second is involved and inventive step. Third is industrially applicable. So this is be mentioned in under the section 12 of Patent Act. Another thing that innovation is a process to take that invention and convert it into a commercially viable product, service, or businesses. So means to say here, as a whole, that innovation is talk about commercialization. So some of the innovation product is not confined to the requirement under the patentable invention, because some of innovation they are creating from the others use of the existing knowledge or existing technology they have, but they are reuse technology to solving their own problems or add in to their certain product or services. However, when it comes to the invention, is regarding to the requirement that need to be fulfilled under Section 12 of Patent Act. Okay, so for that invention is can consider is not market focused. Why? Because some of the intention of filing a patent is they want to share to give a signal to the public that the creators invent a new invention. And that one. Second is probably when they are filed that the patent application, they are preparing to ensure that this novelty is referring to the inventor. So because there's needs in terms of time to ensure that their invention or their new product development can be secure, okay, and they are planning to do such an improvement. So from there, when it comes for the next following new patent application, so it already covered that the invention be invented by the same inventor. So this is the process in the technology whereby we talk about the time, you talk about the challenges, you talk about that you need to ensure that new invention must be fast to be protected under the creator's name. So and as a whole, that value proposition, you talk about to deliver a new technology to the end users, to the customer or the consumers, okay, regarding to the quality of invention and the quality of the innovation process. So as a whole, we can see that innovation relates to the commercialization. Invention also relates to the competition, but must fulfill the requirement under the Patent Act. So it can consider that IP, intellectual property, as a new wealth creation in Malaysia. This is the process whereby it is a booster to the economic growth of our nation. So basically, the innovation cycle, it talk about the creation, protection, and utilization. Means that the inventor, they create a new product or new services. Okay, then there needs also to have a protection. I just mentioned just now that the IP give such a recognition and protected under the legal framework. Okay, therefore they need to do to secure their interest by way of filing a patent application example. And the end result of both of creation and protection, there are utilization of invention. So when we talk about the utilization of invention, there's a three sub lip under the utilization is talk about commercialization. Okay, and second, that innovation need to be exploited. We talk about the exploitation and also need to use as an actual use in the market. So sometimes this actual use is a starting point for the new for the further development in terms of the technology development. So this is what we call the cycle on innovation. So this cycle of innovation must be refer or must be consistent with the intention of the business. So the business goals is very important, whereby the purpose of the businesses is talk about you want to create more product and that can contribute to enhance or to increase the revenue of the company. So basically, the target goal for the business is the setting by the board of directors, example, or the owner of the company, example. So this is they have need show some of that the project and activities to ensure that they can have a more and more product that can be available to the market. So to have this kind of project and activities, for sure is a certain is a need for the organization to have a certain aspect of knowledge management enablers. Here, what I try to say that the relationship in the business organization, okay, they need to get involved of that this knowledge management enablers. So when talk about knowledge management enablers, so we cannot forgo the importance of the intellectual property. I just mentioned just now that intellectual property is talk about the intellectual creation. So means to say that there's a such enablers for the knowledge management to need consider IP in their day-to-day business operation. So and of course is need very what call very smooth or very support with the intellectual resources. This is the thing how the innovation and also that the business goals have a significant relationship between both of them. So when talk about this intellectual cycle relates to the intellectual property, innovation cycle relates to intellectual property, I just to share how the relationship with the innovation. One, there's a part of pre-commercialization, and second, another side is on the commercialization. So I just share to you, this is the scenario that how the movement of the managing of IP can help, can support the business orientation of the business management. So of course, there's a same intention when you talk about businesses. Your goal is to have what is can increase your revenue from time to time. So it's also same with the intellectual property. It's talk about the monetization. Okay, to have this monetization is just not talk about selling your product, but you also need to have a certain knowledge how to manage this IP. So when talk about managing IP, so it's also involved the intention of the business development. Okay. And it must relate with the regulation and standards that they provide under the IP system or the IP legal framework example. So at the same time, when you talk about pattern, you talk about the solution to the new given a solution given solution to the problem in the field of technology. So you can able to identify the technology trend and also the market requirement. So this is how this the connection between the intellectual creation and also the interest of having a new product in the market. They are close related to the technology trend and market requirement with the requirement under the patentability. And of course, the research and capability of the government also contribute the relationship between business and also intellectual property. This is the expectation have or the expectation made by the stakeholders. Okay, how we want to say that this sufficient relationship between the businesses and also the intellectual property. Let me just share with you. I will share with you that turning technology management to intellectual property perspective. So here, as I mentioned just now, we start with the pre-commercialization. Okay, under intellectual property, there's many model or module or certain tools that the businesses need to try to understand or try to get to know. One, because it will make sure that you can organize your innovation in the better business environment. So here, in terms of that IP management, okay, as a whole, I just mentioned just now the pathway to IP monetization just now. So you need a certain model that can be support your business management. One, we start with the IP management as a whole. What you have, you can identify your IP portfolio. Example here. So this IP portfolio means that you have pattern, you have trademarks related to the brand, you have industrial design related to the packaging example, and of course, this is for sure. It start with the IP strategy. The IP strategy is more or less is talk about close related to the business strategy. Okay, and as example, I give you example when talk about the nanotechnology. Of course, before you try to invent something, you do a surveillance. You do a due diligence or you do the what you call market segment. So of course, when relate to the IP strategy, it can reflect to how you want to ensure that the proposed new technology is not not conflicting with the existing pattern. So this must be also support with you need as what intellectual capital. When you talk about intellectual capital, is you are managing. There's a three criteria for this intellectual capital. One is talk about the human capital, which reflect to your employee knowledge, skill, and experience in terms of the technology. Okay. Second is talk about the organization capital. Okay, is regarding to the structural capital. So it means that the firm, okay, the business organization must have a certain knowledge regarding to technology, the database, and also the culture of this relate to the proposal new invention. And third, we talk about the social capital. So some we call a social capital as a relational capital, whereby this comes to the new target under the goal of the IR 4.0, whereby the government encourage the partnership between the businesses and also the public industry, example, or research institution. So when you have the social capital, so you can able to have what we call sharing the knowledge in that particular field of technology. So when you have this understanding on this IP model, okay, of course, this will also be connected to the strategy or the planning when you want to go for protecting your invention under the patent law. So here, every stage that you want to have a new invention, start from the example, the prototype, okay? Under the patent law, or the practice that you should have to be used is always start with the pattern searching. When you talk about pattern searching, you also have what called go through what is available in the publication search. So this is to ensure that you not waste your time and your money okay, to ensure that this new proposal is there's no certain conflicting with the existing technology in the market, example, because one of the requirement of under the patentability is a novelty. So that is important of having this patent searching. So in the same time, you talk about the IP strategy. It also can do a certain correspondent with your business partner, example, or you can have a certain communication with the existing owner of patent, but you want to enhance that particular invention, example, so you can do such a collaboration. That's the thing. So the second step that you need is having the patent drafting, okay, and also later this when come with the patent drafting, you have the full package of the patent specification. So before you go further for the patent filing, is be advised that use to do again as a due diligence to check for the patent searching, because for each patent application, they are only available the information in the market, okay, 18 months from the date of filing. Therefore, means that you have what we call a grey period or the grey lack of the information within that 18 months. So when you do such last due diligence, you can able to check that whether your proposed concept of invention is still not conflicting with the existing invention or existing technology in the world. Because regarding to the novelty is a talk about uniqueness, novelty in the world. And of course, you also have the option, either you go for the national route or the international. So for the international route, they call a patent cooperation treaty, whereby this is one of the suggestion that you use this specific route for you. You can save your cost and also you can save in terms of your time. This is a way of doing things when you want to extend your protection in the other countries, because IP treaty talk about territorial rights. So it means that if you want to protect your invention, you also need to file your patent or your brand, your trademark in other countries. Okay. And for sure, one thing, if you are continually want to apply to proceed with your protecting your invention, you must remember to file a request for subsequent exemption, because this is another factors that some of the applicants they forget to apply the request for subsequent exemption, as they consider, they assume that when do a patent filing, so means that already be covered, will be taken care of by the MIPO, example. Actually, the process first, as I just mentioned just now, that when you file a patent, so means you are notified to the public that you are inventing a new technology. In order for you to secure your protection for your invention, you need to do a request for subsequent exemption. That is the process under the patent law. And you can see here, the management of IP and also the process under the patent law, they are coincide each other. So they are what called side by side. So you need this kind of understanding, so it's able to protect you from every angle, not only for not only under the law, but also in same time it can manage for you to help you to manage your businesses. Okay, the second one is talk about commercialization. Just now, you talk about the pre-commercialization. So we assume that you already give a grant of patent. Okay, so now you will go for the commercialization. So just mentioned just now, this talk about the overview, the how the relationship between the businesses and also intellectual property. So for the conversation, of course, I just mentioned in the early that IP is talk about monopoly. So when you talk about monopoly, one thing to support for the conversation, the law itself gives you such a right, called exclusive right under Section 36, that you are able to exploit the patented invention. You also have able to assign or transmit the patent, and thirdly is to conclude license context. Okay, we will discuss on this how is the support on the compensation, and at the same time as legal rights, you can make such protection to ensure that no third party just simply to use your invention or your innovation. Okay, you can able to have a civil action by way of request for injunction, and also if you can able to win your case, you can ask for the award of damages. And under patent law also is the infringement of a patent is can consider as a criminal offence under Section 64. Okay, what is that the compensation provide under the IP for innovation? One is talk about assignment just now. Okay, when you talk about assignment, you are transferring your rights to the third party. So means you are transferring you as a assigner, you are transfer your IP rights. Example here for your patent to the assignee. Okay, and the assignee becomes the new owner of the IP right. So this is what we call as an intangible asset. You are selling your intangible asset. So as you sell your intangible asset, of course, for the business, you get immediate cash flow return. Okay. And also, however, there's advantage that you have lost of right and control over the IP. Just to remind that for the patent, under the patent protection, in order for you to continue the ownership, you must ensure that you pay the renewal fee every year. Because under the patent law, in order for you to have exclusive rights, you need to renew each year for until 20 years. Okay. Okay, what is the consideration when you conduct this assignment, the transfer right? You must make sure that you are the owner of the property, okay, and also the assignee become a new owner, okay, as a new ownership, and the validity of the IP, okay, is need also to ensure that you not encroach of any others others people patent rights, and again through the process, the risk that you need to consider when you through the negotiation to see how for example how that the technology that you assign can be continually operated by the assignee. Example, the know-how, know-how, the know-how technology is very highly needed. Maybe it can be conducted by through training. The process, how the process of produce that that product. Example, price of the IP, price of intellectual property. So this you have to decide whether you go one lump sum or you go by partial payment, or it depends on both parties. And also legal requirement, also need to consider the form of the assignment, and you also must consider the registration of the assignment to file in at the IP office, example. And again, that in terms of this, there's others consideration. Either you talk about the non-disclosure agreement on the know-how issue, or you can talk about the warranties and registration. This is the concern when you talk about the assignment of patent. Okay, another one that talk about communication. This is what call normals in the market. Some when they are not transferring their patent rights, they are proposed for the licensing. So when you talk about licensing, is issue on the licensor give permission to use the IP to the licensee. So as I use just now, you can see that when you file a patent application and just waiting for the patent grant, the process, the search and admission by the patent examiner, we call as a patent pending. So during the patent pending, and you are absolutely clear and sure that your patent can go through the process for the search and admission by the patent examiner, you can at any time you can give such a what call reminder to the party who use this new invention, okay, by having a certain agreement in terms of the future licensing example, or you talk about you give such permission for them to use in the context of know-how example. But however, if the third party still just ignore your reminder, so you also can put such a notice to them that they can be capable to have infringement proceeding, civil action against them in event when you receive your patent grant. So when you receive your patent grant, then you can start your litigation action against that third party which they are used your invention okay, without permission from licensor. So there's a few types of licensing. One is exclusive rights. So means here you are given them absolute license to the third party. And also second is the non-exclusive rights. So non-exclusive right means that you can give one or more parties. So in this non-exclusive rights, at the same time you can give a condition for different parties, and also it depends on the territorial example. The third one, you talk about sole license. Here is more that you the recipient transfer all rights to exploitation of the IP to the licensee, but retain his right to exploit the IP itself. And the fourth one is talk about cross licensing. This is one way to what call to avoid any legal battle between one party to another party. So they are sharing their invention or their technology by doing the process of cross licensing. So this mostly is what called to harmonize the issue of using the technology from one party to another using using the technology between them. So what you do here is they go the process on the cross licensing. Okay. So in terms of an IP license agreement, this is what you need. This is only the part of the recommended when terms, recommended terms that when you do a licensing agreement. So you need to consider the definition, okay, the grant of rights, what is the term slide, the territorial, okay, either is exclusive or not, okay. Improvement, this is another issue that in the event that any parties have improved in that kind of technology, whether how they decide whether there will become as what call what partnership, or they call what call joint owner for the new improvement of technology example. So what about the know-how and technical assistance example? You get involved for the training, you provide for the training, for the building for that particular parties involved. So they also need to know how the process of that operation of in producing the technology. So it can go by way of training. So regarding the confidential information, is very important. This relate to non-disclosure agreement. Okay, you can also consider it under the IP license agreement that any confidential information cannot be disputed by any parties. So this is the list. What you have regarding IP infringement example. Who can take action example. How you want to convey if one party have a knowledge that there's another party who use your patent without the permission. So how you want to go. And also issue regarding to the sub-licensing or assignment. Okay, this is also must be considered because sometimes if you have the what call the opportunity for extend this technology by way of sub-licensing example. Because I mentioned just now is how you monetize your IP, and also this how you want to enhance, to increase, to enrich your business portfolio. So sometimes you need make a decision to have a sub-licensing. And termination of this IP licensing agreement also must be clear whether it's an end for a certain period or there's a plus terms. We consider to renew that licensing agreement. And last, there's also we talk about the boilerplate provision. This regarding to any requirement that you need to fulfill, either under the governing law. There's we talk about the dispute resolution. This is the what list of terms that we normally use under the IP license agreement. So that's all for my sharing knowledge regarding to our talk for today. Is overview on the commercialization from IP perspective. Hopes that all of you who join to view this video able to have a certain understanding, okay, have a certain inspiration. You're inspired to having more understanding on the intellectual property and also how to manage intellectual property together with your business management. So hope this will encourage all of you to improvise your business, not only your business capability, but also you have enhanced. You can enhance your understanding on intellectual property. So thank you very much. For any further questions, you can contact. You can browse mypo.gov.my, or you can contact the organizer for further question. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Encik Muhammad Fairuz, on your presentation. To our dear viewers and participants, if there are questions related to our current session today, you may drop your questions together with your email address at the comment section. Our staff is pleased to help you as soon as this session ended. Viewers and participants, sadly, we have come to an end of our webinar. But before that, I would like to remind that we will have other sessions of Nanotech Talk with more topics that covers by our industry partners. We would like to thank you for your generous time today. Thank you once again to our partners, speakers, and participants for joining us today. Terima kasih, stay safe. We'll see you soon on our next session soon. Bye-bye.